We are honored and thrilled to welcome today's speaker, Mr. James Brosnahan, who's here to discuss some of the most consequential Supreme Court cases decided over the past year. Mr. Brosnahan is a renowned defense lawyer, former federal prosecutor, author, and advocate. He's tried more than 150 jury trials and is a member of the California Trial Lawyers Hall of Fame. The Law Library is deeply grateful for his longtime support of our library, and as always, we are honored to have him speak here. He's a true champion of access to justice and has dedicated his career to advancing the public understanding of the law and the vital role the rule of law plays in our society. Please join me in welcoming Mr. James Brosnahan.
Thank you very much. I'm delighted to be again at the Law Library and pleased to know the work that you do. It's terrific. It's a great service for a lot of people. When talking about the Supreme Court, which I'm going to do, and talk about the specific cases, you have to try to be objective. I would say this year is not easy. But I'm going to do my best, and I'm going to leave some time for questions at the end, and look forward to hearing, what you think about it. Um, some of these cases are earth-shaking cases of profound impact on the law and on the future of the country. That's a big statement. But let me start with Trump versus Barbara, etc. The 14th Amendment is quite clear that a person born in the United States is the United States citizen. We'll get to the exact language in a minute. But it has suddenly become controversial. And it has become controversial in the context of mass deportations. And once that fever hits, where huge numbers of people are being deported, then it's been carried further to question the citizenship of some of the people who are here. What are we talking about? We're talking about the case where the parents are non-residents. They may have some basis to be in the United States, but they're not citizens. On the conservative side of things, they took that and tried to get the Supreme Court to say that people who were born of the undocumented are actually, even though they're born in the United States, are not citizens. And this is an overall purge that is going on in a number of areas and has resulted in several cases, which we will certainly get to. In this case, five justices, Roberts, Sotomayor, Kagan, Barrett, and Johnson. So notice that Roberts and Barrett, two conservatives, have held that the children of undocumented people who are born in the United States are American citizens. There were four justices who disagreed with that, and the observers yesterday were shocked that four people thought, no, we're going to exclude them, deport them. They're going to be part of this mass deportation that's going on all over the country. Wong Kim Ark was born in the United States and went to China to visit relatives. When he tried to come back, they excluded him. He went to the U.S. Supreme Court in 1898. And this got lost in the press coverage yesterday. And he went to the U.S. Supreme Court, and the court held the language of the 14th Amendment is very clear. all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That court, all those years ago, said it's very clear, they're citizens. And that has been the rule for all those years, 128 years. And now the conservative movement has come along and said, no, we found an argument that means that they're really not citizens. That argument is faulty. I'm sorry. But four justices, Kavanaugh, Thomas, Gorsuch, and Alito, all wanted to declare them non-citizens. This gives you a flavor of the conservative nature of the Supreme Court. And we'll get to some other cases today where that conservative trend was effective and conservative rules were passed. This one, that case was one of the ones that really scared people a lot because there's a trend going on much broader than this. And I just finished writing a book about the excluded, but which is neither here nor there. But the effort to exclude people, and particularly people of color, is in full throttle as we go along, but not if you're born in the United States. So that case is very important for the future. The next case has to do with the Immigration and Nationality Act of 1952. And in that case, which is Mullen, Secretary of Homeland Security versus Al Otro Lado, here's the vote was Alito for 6. Now that's those are your conservatives. Those are all conservatives, and a dissent by Sotomayor, Kagan, and Jackson. Those are the liberals, if you will, and they dissented. What happened in this case? In this case, Congress passed a statute a number of years ago, and the statute allowed asylum. So, for example, if in El Salvador there's a revolution going on and there are people who are being persecuted and they flee and they come to the United States, there's a process in courts which allows them to claim that they had to come because of asylum. The roots of that doctrine go way back, and interesting enough, are in the Bible. I was a stranger, and you let me in. Those are the words of Jesus in the Bible. And there's a moral issue here, and it's been back and forth for a number of years now. There's a moral issue about what responsibility a country has to take people in versus the flood of people that come to the United States, which years ago we had a vacant land, except for Native Americans, and we needed people to build railroads, among other things. And now we don't feel that way as a country. And as you know, that's a very controversial political issue. But here's what the court did. And this I have to call cute. This is a cute little trick. Asylum is a process by which an alien who arrives in the United States, the conservatives took the word arrives in the United States to mean that you can stop them at the border. Well, what had been done was they indicated that they wanted to apply for asylum, and the legal process, which is now eradicated, has been eliminated by this decision because they have argued, well, you have to get into the United States before you can claim asylum, but they won't let them in at the gates. So the only way you could get in is through the desert, led by a coyote who charges too much money and sometimes leaves people in the desert without water. It's quite a story. So Alito wrote the opinion for six, focusing on the word arrives. And so when they come to the gates and they say, I want to claim asylum, they haven't arrived in the United States. Since they haven't arrived in the United States, they cannot apply. It is an effective repeal of a statute passed by Congress that's been in effect for about 30, 40 years. And it tends to show the willingness of the conservatives on the court to be result-oriented versus careful analysis. I don't say that lightly because there's other cases too where you're going to see it. Okay. The court held they had no jurisdiction in a case called Mullen versus Doe, Alito for six. And the court said they had no jurisdiction to deal with this. The question presented is whether respondents who challenge the termination of temporary protected status, what is that? TPS, for aliens from Syria and Haiti. There are many other countries where people get TPS, temporary protected status. This is not limited to persecution of people, but rather conditions which make it intolerable to try to live in that country at that time. And in Syria and in Haiti, people were let into the country. The president, and now we arrive at a theory long held in groups like the Federalist Society and other groups that what we really needed in this country was an extremely powerful president. If I may, that is contra to what the feelings were in the foundation of this country and the drawing up of the Constitution. The Constitution has three parts to it deliberately. Those were first proposed by Montesquieu, a French philosopher in the 1700s, and it was quite a courageous thing that he did. But he thought that having three departments would be a safeguard against corruption and excessive power. Well, the founders of our country took those three departments, as you know, you well know this, took those three departments and put them in the corporation. And each one has rights, and each one has prerogatives. And the congressional prerogatives in the last year and a half have been usurped by the President of the United States with the support of the Supreme Court very often, who have those members for a long time have wanted an extremely powerful president. Okay. So in this case, I want to quote you the dissent, and it's the same three, Sotomayor, um, and the other two are dissenting. Both courts concluded that the secretary probably violated the TPS statute by ordering the termination. That means sending 350 in one case, 350,000 people, and the other one is smaller but is also large, back to their home countries. Probably violated the TPS statute by ordering the terminations without first consulting with other agencies about current country conditions. That is, they were allowed to come here because of the conditions in those countries, but nobody checked now and just canceled it. This is an example of the power of the president at the moment. And we'll come back to that again and again. Title IX, Equal Protection and the 14th Amendment. Can a trans person play in the games of his or her, but his new sports team? Supreme Court says no. Written by Kavanaugh, the term biological um, uh, is used in the decision, and there is a dissent. I think many people find this a tough question because if the trans person converted from male to female and is larger, stronger, faster, whatever, you at least wonder whether that's appropriate. The majority says no, it's not appropriate, and they hold that this cannot be. On the other side of the argument, a trans person is in the process, of course, of acclimating in full participation in the gender that's there. We knew without any question that the trans people and, in fact, gay people everywhere were in trouble when the president signed a piece of paper. He sat at a desk, his first day, and he signed a piece of paper which said that there are only two genders. Only God can decide genders, not the President of the United States. I promised myself I wouldn't get all wrapped up here, so I'll calm down. Two genders coming from where? Anyway, this is a very simple idea for a democracy, and that is why don't we let everybody have choice unless it hurts somebody? And why don't we go back to that? Because this court is taking us in a different direction. All right. So what they held was that in the number of states, about 30 states that have statutes that forbid trans people from participating, you have to be your original biological birth, that can be tolerated, that can be okay, and that they can do that. The dissent, I thought, was a little shaky, but they tried to argue that more had to be looked into in each case and all that. Well, that's problematic, maybe, in each school as to what they're going to do about it. and you may well have your own view of this. Many people do. Um, this is part of a much bigger picture, which is the elimination of diversity. Very interesting. Not only gender, but diversity. There isn't any anymore. I don't know if you knew that. Because if you're out in the world walking around meeting people, it might not occur to you that there's no diversity. That's why we have St. Patrick's Day for those of us who are Irish Americans, and it's why we study our history. But that's that case has been decided. Now, we're living in a period with a overpowering suggestion that elections are corrupt, there's cheating. No one can find it. I mean, I'm talking about hundreds of people, maybe thousands of people who are in charge of taking care of elections who don't find it. But once the leader on the conservative side declared that it was true and repeated it over and over again and began looking for it, there were those who followed those instincts. So here we have ballots that are sent before the election. And for example, uh, absentee ballots certainly includes people who are housebound, they're of age, they can't go out and so forth. And the absentee ballots are very important. But they sit down, they vote, they send it. But for whatever reason, it might be the post office, it doesn't get there until a few days after the election. Should those be counted? Is this part of an overall program to reduce the number of people who vote in the United States? Yes. Who's doing that? The Republican Party is doing that. And this court said that those ballots are valid. And that's the first of what will be several other cases that come. The the votes were included Barrett, Roberts, and the three progressives, if you will, Sotomayor and so forth. Those five. And Alito was for four. He wanted to not count the ballots. This is part of an ongoing, powerful drive for the President of the United States. If he says it, we got to all do it. I have words to describe that, but I'll spare you that. Um, so that is one of the voting cases. Um, Now this one is technical. I thought it was very technical, but it has to do with the power of political parties in receiving monies. And you may wonder why you're limited in how much you can contribute, but certain groups out there somewhere in the cloud can make unlimited. You're talking millions and millions of dollars contribute. They can do that. That Supreme Court structured all that. Now they want to not change it, but what they did do is empower political parties to work directly with candidates and to receive unlimited funds. And that will change. And I don't think we quite know the details of that yet. But it hasn't changed the idea that millions of dollars can be contributed by some and others are limited. never understood a coherent explanation as to how you can have that in a democracy. And the heart of the problem was when they declared that money was speech. Um, I'm sorry. I mean, I've had money in my pocket that never spoke to me. I mean, but in a way, it is speech because if you give $1 million or $5 million or $100 million to a candidate, um, you've spoken. And by the way, you will have dinner with them. Okay. All right. Um, here's a uh, case: Trump versus Cook, and this one you can pick at this, but still, most people would agree with the result. What is the result? The result is the president cannot. Okay, limitation on presidential power. The president cannot fire a person in the Federal Reserve. Why? Because there is a history of national banking and objectivity. If you want my footnote on this, it scared the Supreme Court if they allowed this kind of um, activity. So Roberts for five and Thomas for four. There's the conservatives again. Wants to give the president the power to fire people in the Federal Reserve. Every day in the Wall Street Journal, there's what the Federal Reserve is likely to do, what they're going to do, what they should have done, columns and so forth. It is, I agree, a centerpiece of the economics of a corporate country, which is what we have. However, the next case, so you can't fire Miss Cook, except you could if it was for cause. So there's no doubt the Department of Justice is off looking for anything they can find, but they can't just fire a person in the Federal Reserve. What about all the other agencies? That's that's big news. And here it is. Uh, there's a two people in the uh, an agency. One of them is named Slaughter. This is called the Slaughter case. And the Federal Trade Commission is one of the agencies that does a lot until this decision this week. The people who were in these commissions had a certain protection to keep them out of politics. Sotomayor, in her dissent, points that out, that a president appoints people and then you can't just come along and fire them. But we're in a wave of presidential power. And that's what the president did. He fired two Democratic regulators on these agencies. And Roberts for six said the president can do that. What does it mean? At the heart of theory, the heart of theory about corporations and how they can work. How can they work for the people? How can they work best for citizens in a democracy? The moderates have long held there has to be regulation. Without regulation, it is thought, and there are examples all over the place. You could mention a couple of industries right now. Without regulation, there is no protection against excessive corporate steps. And that's going to hurt the people. That's going to hurt in a lot of different ways. It could certainly hurt in terms of prices, like gasoline, for example. And that's a good example. I've followed, at one time I tried several antitrust cases, but I've been following for a long time the lack of enforcement of the antitrust laws. And I will mention I brought two cases against oil companies. And here we are. There wasn't a word about the excessive prices. There wasn't a word about the income of the officials. And I followed that. It's a good thing to be an official right now in an oil company. And yet, that quietness allows it. Well, okay. So, what does this mean? It means the President of the United States can fire any regulators that he wants. That's my interpretation. Reading this case, they can now do that. And um, what does that mean? It means that, and I have no reason to believe that President Trump won't do this, a little bit of a forecasting of the future. He'll wipe out the Democrats who have certain regulatory expertise, regulatory experience, and regulatory philosophies, and he will remove them. And corporate America will benefit from whoever he puts in. And that's a dramatic thing to have it happen. And specifically, Roberts again for six, same six, and dissent by three, the same three, Kagan, Jackson, Sotomayor. They point out in their dissent, for the last 140 years, the system has been to insulate to some extent regulators from the interference of a particular president with a particular approach to or for corporations. And by the way, I just want to observe, we're in a very interesting time on questions like whether the taxation structure should include corporate leaders who have amassed enormous fortunes. That's an issue that is getting debated back and forth. It's in California, it's on some of the ballots, and the question is yes or no, and the implications of it. And maybe they'll be upset and move to Florida and so forth. It's a very interesting issue to follow, I think. Um, uh, so um, there's Article 2 of the Constitution um, suggests, lightly at least, that there should be some basis for termination of a regulator. And when the country started, there wasn't much regulation. There weren't many corporations. But that one is something to watch and to notice as we go ahead. And as to the quality of regulation, what are we talking about? We're talking about all kinds of regulation. We're talking about health regulations, among other things. We've already seen what happens with the new health director. I noticed he was quoted as saying he wanted to reduce pills for depression. That's a big subject, and but it shows you the power of having control over regulations if you want to go to an extreme. And what I'm saying is that there will be extremes now with these regulations. Regulators aren't always correct. I mean, I've appeared before regulatory bodies and been surprised or even shocked at their attitudes and the lack of understanding maybe as to the details of a corporation, how it really works, that kind of thing. But mostly they're doing their job and they're trying to protect people like you and me and others. But that is now in jeopardy by the slaughter case. The slaughter case. Okay. Um, there's a Fourth Amendment case, and um, there's a it's very interesting. Technology has come along. There's something called the geofence warrant. What is a geofence warrant? A geofence warrant is one that you can put into action and plug in some telephone numbers. May not be doing this justice, but I'm doing the best I can. And it will tell you where that was at a given time. It'll also tell you where everybody else was, according to the facts of this case. Well, that means there are all these other people who haven't done anything wrong, they're not suspected of anything, and yet the government is is investigating and receiving information as to where all these other people were at a given time. Well, it makes having a secret date almost impossible. So, but here's what happened. They plugged in a suspect's number and they got all the other numbers, which by itself is a Fourth Amendment violation. There's no basis, there's no probable cause for all those other people. But and probably those people don't even know that the government has that data. And so then the when they got something like 150 phones in the area in question, um, the question was then they what they did the next step was to exercise a search and seizure which had been approved. And the question really was the connection between the preliminary technological survey on the one hand, and then followed by a more conventional search and seizure. Six justices, again, same six, for Kagan, written by Kagan, and three by Alito. They sent it back to the Court of Appeals to question the probable cause. And the idea is if they had probable cause for a warrant, then it'd be okay, even though it has this history of doing this technological search there. So certainly the criminal lawyers will want to take a look at that. Um, Want to leave some time for questions. Um, the Second Amendment um, is, of course, the right to carry a gun. And I've noticed over the years a slight limitation on the ferocity of Second Amendment applications by the conservatives. In other words, they said, okay, you have an absolute right to a gun. And there's a couple of cases here. In this case, the United States versus Hemani, um, um, he's a dual citizen and he's a um, casual user of marijuana. So now, what does that mean in terms of law? Well, the record shows that he would use marijuana every 3 days. There's case law here you may be familiar with, which is that if you're on drugs, uh, that may be a reason. There's a previous case in the Supreme Court. That can be a reason to not allow you to carry a gun. I mean, if you're just zonked out of your mind, then even this court is ready to say, well, maybe we shouldn't allow that. I mean, a limitation. There's very few limitations, but there are a couple on carrying a gun. Um, in this one, though, uh, he is a casual user of marijuana, and they forbade him from carrying a gun. The court says no. Gorsuch writes for a unanimous. Notice this is the only unanimous case that I have found so far, in my discussion at least. And he finds that you can't forbid the carrying of a gun if it's a casual use of marijuana. Okay, and we let the trial judges decide, was it casual, was it serious? I don't know. It's kind of a funny rule, but that's it. Meanwhile, out in Hawaii, they had a limitation on guns under the Second Amendment, and it was kind of vast, I thought, and it provided that if you were going to carry a gun onto private property, you had to get the permission of the owner of the private property. Well, private property includes stores and, coffee shops and all that kind of thing. And so in that case, they struck down the Hawaii statute. And so that's another limitation of of that case of the Second Amendment, enforcement of the Second Amendment. The name of that case is Walford versus Hawaii, and um, it's long been held that people can carry guns for self-defense in public. Of the Hawaii law that prohibits firearms on private property open to the public without the express and affirmative consent of the property owner. I was just thinking you invite, 20 people to your house and somebody says, I want to bring a gun. Well, not so much. But that's that in that case, they struck it down. What's the takeaway on the Second Amendment? They're going to strike down any serious deprivation of the right to carry guns uh, in public, certainly in private. And on the other side of the argument are the number of people killed um, by guns in the course of a year. I just finished watching, I'm behind in my television. I watched The Wire. I don't know if any of you ever watched that. It goes back several years ago. But the shooting in the neighborhoods and all of that, and we have that here. We have that in San Francisco. The shootings on Route 80 um, and all of that. So there's the balance somewhere between the right to carry a gun, and the conservatives have carried that beyond regulation. And I will say that the regulation of the absence of regulation of guns makes it stand out to anything else. For example, if you want a license for your automobile, which can kill people and does, other cars, not yours, but it does, there's a whole process, and they check the eyes, and you have to sit in the motor vehicles place and wait your turn and uh, do whatever examinations there are and follow whatever regulations there are, and you have to take a test and you have to do that. But the guns have been elevated to a position, and the result has been an awful lot of people die. Um, those are the high points of the day, and I've left some time for questions, and you can put them on chat if you want. And there are some calls on chat, or you can just ask me live. So let's take a look at chat and see. Um,
Yeah,
uh,
please go ahead and put your questions in the chat, everyone.
mhm. Here's somebody says something I agree with. The Wire is the greatest television show of all time. I'd go along with that. You are transported into another life, another region filled with friction and reality, and it gave an opportunity for, I don't know, 75 black actors. And they were, of course, tremendous. That show never had a slow time in it. It just one thing after the other. And once I started watching it, and so forth, uh, I have to say I have very deep appreciation for your candor, Mr. Brosnahan. That could be my wife typing that. I don't know. Um, here, here's, you know, I argued two cases in the Supreme Court. It was a different court. It was conservative. There were conservative justices, and but there was a rational procedure for most of them that they went through on both sides, and they were proud of the procedure. And there were rules. There were a lot of rules, and you had to know the rules. Here, this court has given the power of the government to the president. And that theory has been knocking around in the various conservative parts of the operation for a long time. And now they have it. Here's a question for you. See if you agree with this. I keep thinking I'll do an article on this. And that um, is a judge responsible for the foreseeable consequences of a ruling? That's a complicated question. For example, judges in the district courts have to sentence people, and at some level, they're quite aware of what happens in jails. And some of those judges go and take tours and hear stories and understand the brutality of jails. And so they foresee it, but they don't have any control over it because the laws of sentencing are what they are and all that. On the other hand, here's a question I wouldn't dare ask if I was standing at the lectern in the Supreme Court. And that is, do you have in mind the consequences of giving all this power to the president? You must read the papers. You must know what he's doing. You must understand that and here's where the words bounce off people. Is he authoritarian? Is it more than that? Much more? I think so. And that's in my book. What I did in the book is I traced the history of the excluded. And guess when women were excluded? I start with the early Greeks, and basically it comes all the way through. And then you get to America, and they weren't included for voting all the way through to 1920. And the arguments, I don't want to go on too long about this because you can't buy this book anywhere yet. But the arguments about what women could do and could not do were fanciful. There's a wonderful quotation by Quintilian, who lived in 100 AD, and he taught oratory, and he had women in his class. And he said, they're really very good. Of course they're good. Of course they could be if they would be allowed to be. And so now we get to a conservative court that wants to go back to something. And part of the administration that's facing them and arguing in front of them is clearly on a track to go back to a white supremacy in some form. And there's a lot of things wrong with that, not the least of which not taking advantage of the talent of a diverse country. And I saw a list recently of the immigrants who accomplished things. You'd know every name on that list. So anyway, candor is good now. Should be in, and we've got work to do, I think, in terms of the court. Our problem is that these justices, Roberts, just to mention, I meant to do this at the beginning. Roberts is a person, if he were walking on the street, you saw him, you would say, he must be Chief Justice. I mean, he should be. And yet, he has almost no control over this court. He's conservative, so he happily joins, as he did in some of these cases. But there are times when his comrades are out of control. I think he worries, but can't figure out what to do about it. And the, if you want candor, the experiment with a totally powerful president is an abstract failure. And I'm not the only one in this country that thinks that. So that's what we're in the middle. It's very interesting. I keep thinking I won't watch, developments, and it's somewhat depressing to watch the court now, for specific reasons, because they're giving all this power to someone. But I can't stop. I've been doing it for a number of years. One day, I was lecturing last week on advocacy, persuasion, to a group of lawyers in California. And one of the things we were talking about is responding to the judge. And I was in the Supreme Court, and a justice asked the lawyer at the lectern a question. And he said, the justice asked the question, and the lawyer looked up at him and said, "We'll get to that later, okay? Um, when are we going to get to a reasonable return to a balanced Supreme Court?" It could be a long time. Do you predict any changes in the makeup of the court in the next year? Yes, but not predict? No, because people hang in there and all of that. I will say there was a dissent by Thomas. It was 91 pages, and there is a problem, and I hope I'm not guilty of it, where people of maturity, people of age, start talking and they don't stop. And it can come early, in the 70s, or it can come later. But it's something you encounter, when you're talking to people. And 91 pages is an awful lot for a dissent. And I think that there are legitimate questions about Thomas, and not just his rulings and not just his conservative absolutist agreements, but his arguments and his opinions. But rather, maybe he should step down. And so that's one. Alito is very interesting to me. I actually met him. He's very nice, and I met his wife, who was very nice and invited me to to use their cabin up in Montana or something. And I don't know what Justice Alito would have thought about that, but anyway, it was a nice offer. It was fine. So Alito has a history of always working for the government. I mean, all the way through, prosecutor, you name it, Department of Justice, and so forth. There is a balance in law. There's something about practicing law that, in talking to all kinds of people and understanding their problems and all of that. And his cases, I've been doing this for 25 years. His cases are just rock-ridged government decisions. It'll limit civil rights, and it'll increase enforcement, and it's just one of those things with him. So will he step aside? I don't know. Will the president be president? That's a big question, I think, the way it's going. And if there was someone else, would it make any difference who was appointing the replacements if there was somebody who stepped down? Um, there's rumors about some health issues on the court, um, and on the Democratic side even. And so we'll see what happens. And that's my answer to that. Um, okay. Any other questions that anybody has?
I might have one question. How easy, Mr. Brosnahan, how easy do you think it is to wipe away some of these decisions that just seem beyond the pale of what's like acceptable or reasonable? Could a future Supreme Court say just that was crazy and we're not following it? Or what level of deference in some future world might these decisions actually be afforded?
I think it's a great question because I've thought about it. And I think it depends very much on the nature of the case and what has happened out there in the world. If everybody has changed their approaches based on this decision, that's one thing. But if it more likely some of these decisions really will not work. If I've been guessing, if I'm correct that President Trump is going to wipe away all the Democratic regulators, or almost all of them, that's not going to work. It's not going to work because people will be paying more, because their health will be endangered, because radical corporate theory, and there is such a thing, is an unregulated corporate world is just not going to work. But I'll tell you, this is just, I taught oratory persuasion at Cal in Berkeley. I love the course, and we talk about how to stir people up. I'm waiting for a Democratic leader to make the Supreme Court an issue with a plan as to what they would do. And that, I think, would help to answer your question. There's a rebuilding that has to happen. It should happen. I hope will happen. But the damage that's been done, some of it is irreversible, and it isn't just the president. But for example, I've always had a great interest in censorship. I did back in the day. I did a lot of First Amendment cases, which were really interesting. And here we are with school people deciding that you can't read any of these books. That's a direct effect of the conservative grip that has taken over. Um, liberals, I don't know if we're allowed to speak anymore. I'm not sure. Liberals, but there's a great history of liberals who spoke out, and we need that. We don't. It's been in my youth when I listened to certain politicians, I was stirred, I was moved, and I wanted to be part of some part, small part, what they were talking about. Where's that? Is that out of date? I hope not. I hope it's not out of date. But all of that will come back to the repair phase, I hope, which is what you're talking about. But it's very complex. What has been done to the Department of Justice, which I was part of for 5 years. Look at what's going on there. The president barks out, investigate so and so. Yeah. Really? Really? There was a time when that would be a scandal. And so an awful lot of things had to be repaired. But I think it's happening out there, watching the returns in the primaries. Um, I don't I know it's all the gog at the moment, but I don't know what socialism means, and I'm not sure about that whole thing. But there's a lot of rebuilding that has to be done, and it could be a very dynamic time if certain things came together. And that's my answer. I can't give up hope. I don't give up hope. I tell law students when I talk to them, if I could start all over again, this is a great time to be a lawyer. Are you kidding? You can bring all kinds of lawsuits, and the district judges are enjoining everything, and you can do a lot of good right now. And, get it going. Any other questions anybody has? Very much, everybody. Appreciate it. Tried to be neutral.
Thank you, Mr. Brosnahan. We're always so happy to have you at the library and look forward to your new book.
Yeah,
Yes.
thank you.
Thanks to
Okay.
everyone who attended today, too. Thank you so much for being here and supporting the Law Library's programs.
Yeah.
Thank you for having me.